The Placing You First podcast begins in less than 20 seconds.
Visit crcgroup.com to subscribe, download our award-winning tools and intel articles that help you stay aware of emerging issues and trends, or get a snapshot of the insurance marketplace with our industry-leading Ready indexes. You'll find it all on crcgroup.com under Tools and Intel.
Welcome back to the Placing You First podcast, the podcast where we help retail agents stay ahead of the market challenges, strengthen client relationships, and ultimately place business with more confidence. I'm Amanda Knight.
And I'm Scott Gordon.
And today we're diving into a topic that honestly doesn't get enough attention until there's a problem, and that is excess claims notice. Late notice might sound administrative, but in today's market, it can actually have serious consequences, including coverage disputes or even denial.
And the tricky part is that many agents assume the excess layers will simply follow the primary carrier's lead, but that's not always the case anymore.
So today we've called in reinforcements. We are joined by three of Team CRC's finest who deal with these situations every day. We've got Dave Gilfillian, who leads CRC Group's Claims Advocacy team as Chief Claims Officer, Ari Shapiro, Claims Advocacy Director, and Senior Claims Coordinator, Cammie Powell.
This is the Placing You First podcast from CRC Group.
This podcast features news and insights from a vast knowledge base of more than 5,500 associates who write more than $30 billion in premium annually.
Plus, we give you the latest information on what's happening at CRC.
This is the Placing You First podcast.
And now the hosts of the podcast, Amanda Knight and Scott Gordon.
Thanks so much for being here.
Thanks for having us.
All right, so David, let's get started with something broad. Why has excess claims notification come into the spotlight? Are we seeing late notification as a growing issue these days? What's happening?
Yeah, first, our department advocates for coverage, right, for the retail agents and the insureds. When there's coverage issues or disputes, we get involved. And so we deal with late notice to excess carriers and related issues periodically. And, the simple reason why those issues are more in focus is the cost of resolving large claims has continued to grow over time. And there are multiple reasons, but I think you could say they are all driven by one thing, which is that this is a very lucrative field for plaintiffs' attorneys, right? They're not paid by the hour. Typically, they get a cut of what they bring in. And so the bigger the numbers, right, the more they earn. And they've also raised expectations in society through advertising. These guys are everywhere. And then the other part is that they're well funded, okay, because another relatively recent development is they have access to third-party funding. And a really surprising number of plaintiffs' firms are getting investment, basically, from third-party capital. So they're well-funded, they advertise, they promote, they raise expectations, and this results in larger verdicts and settlements. That puts the excess layers in play more frequently, and the related coverage issues, including late notice, are going to come up as a result of that. Now, the carriers want to make a profit, and as the exposures grow, this often results in them taking harder lines on coverage issues, including notice. But to me, the big issue, honestly, is that the process for providing late notice to excess carriers is flawed and not uniform, right? The triggers and the policies vary. Some of them include very squishy language about when to notice. Technically, the obligation to provide the notice in the policy falls on the insured, but it really falls to the retail agent. So a problem would be you don't always know how severe a claim is going to be when they give notice to the primary carrier.
Right.
But they're also not always kept in the loop as the claim develops, right? The retail agent's not always involved and knows that the exposure's changed and that should, trigger to them that they should give advance notice to the excess layers. And another part of that is, ironically, which I think is misplaced, is there's a fear of noticing too often or too many claims, and that somehow it's going to impact their renewal or their ability, and that's not true. If it's an unpaid claim, it doesn't really affect much in terms of the carrier's analysis, right, of your worthiness to be renewed. But I think that sometimes drives retail agents to be overly cautious in providing notice. But there's no clear map, right? You don't notice every layer every time, right? And that lack of clarity and lack of a uniform process causes problems. I'll give one quick example is that I have a matter right now involving a pedestrian that was run over and killed by a commercial truck where the driver had a stolen commercial driver's license and fled the scene. There were two excess layers, 3 million excess of the 2 million primary and 15 million excess of that 5 million, both placed by the same managing general agent with overlapping Lloyd's of London markets participating on the two coverages, but with different notice provisions. So a very large retail agent tried to notice both layers utilizing the notice to the TPA set forth in the 3 million layer policy. And it wasn't discovered until over a year later when there was a time demand for the whole $22 million of limits that notice was wrong. And they had to scramble to provide notice to the $15 million layer, which made it impossible to meet the timely demand, which resulted in the plaintiffs filing a different lawsuit and including different parties. Ultimately, they did not issue a denial and they're participating, but it caused a lot of disruption and anxiety and could have resulted in a real fight over coverage.
So, Ari, is this something that retail agents, it's something they need to think about earlier maybe than they have historically, not just more often, but also maybe earlier in the process based on what Dave just shared?
Yeah, 100%. I mean, it's funny. I get the question a lot from brokers. When should I report this? Or I've got this going on. We're not sure. Should I report it? And the time that I have been at CRC, and I think in my entire career before that, I'm not sure I've ever said no to that question, right? If you're already at a point where you're thinking, I wonder if this should go to the excess layer, the answer is yes, right? I mean, to Dave's point, there's rarely a harm, right, in noticing them earlier. If it ends up to be a claim they're not paying, it's not going to affect their premium on the back end. And you essentially don't want to give carriers an excuse, right? Don't give them a reason for down the line to say, look, you didn't notice us properly. The early communication, early and often, I think is the best strategy when you're talking about really any claim, but especially excess layers like we're talking about here. Just let them know. Once that thought pops in your head, let them know.
Yeah, and communicate, right? Because, right, the retail agents, again, it's very frustrating because a lot of times they get to our people very late in the game. And the question is, why didn't you reach out earlier? And the same thing is true for the retail agents sometimes with the insureds, where you sit there and go, well, we get this kind of thing all the time. We didn't want, it's like, well, then reach out to them all the time until they say, stop bothering me, right? Because that again, I have another matter where there was a clear demand in writing for, which is a claim under any policy on earth, right? A written demand for monetary compensation. Their legal department had written back and made a small offer. And then they didn't notice the claim until a year later when there was a lawsuit and there was a different policy involved, a different carrier involved. And they managed to impair themselves on both policies by not having reported those communications as a claim. And their explanation was, well, we deal with creative people all the time. It's not a contract. We don't owe them money. They do work to try and put together these submissions, but they're not entitled to compensation. And they come at us all the time. It's like, well, this person came at you claiming you owed $6 million and you guys wrote back and forth. You need to, call your retail agent, let them tell you not to worry about it.
Absolutely. Well, Cammie, I know that Dave shared a couple of examples, but I know you've also been dealing with a couple of real situations recently where excess carriers weren't notified until very late in the process. You want to walk us through one or two of those and kind of give our retail agents an idea of what you see coming across your desk that we want them to try to avoid?
Right. Well, in most cases, we're kind of at a disadvantage because we don't write the primary. So we're not really in the loop
Right.
on a lot of the claim reporting. Both of these cases were sort of similar in that we've got a matter which maybe the primary carrier feels it's going to be well within their limit. They're reserving it well within their primary limit. And then suddenly it escalates. Either you receive a demand that is multiples of their primary limit, or something develops on the matter, and then they're going to notify excess at that point in time. Now, in the two cases that I've actually handled recently, one of those we had a mediation in 2 days, and they wanted the excess notice on carrier. Another one, the trial was beginning the following week, and they want to put the excess carrier on notice. So we've got two similar situations. Now, in one case, the trial fortunately was continued for many months. But at that point in time, when you're trying to notify the excess carrier, then they immediately are going to reserve their rights due to late notice of the matter, because it jeopardizes their opportunity to review the matter. In some cases, depending on the severity, even appointing their own counsel to monitor. And so we've got an insured who is obviously in a panic because they've received a reservation of rights letter, and the agent is in a panic because of the potential E&O on their part for not reporting to the excess carriers. Now, historically, I have so many situations, the claim being reported after a trial and the judgment has been made and it suddenly exceeded the primary. So they want notice to the excess carrier with a copy of the judgment saying, please send money, because this exceeded the primary limit. Or in some cases, there are so many different scenarios. One was a recess in the trial, and defense counsel realized, oh, this could be pretty big. Do we have excess? So during a recess in the trial, they want to scramble and put the excess carrier on notice. So in all of these instances, the excess carrier's rights to review, monitor, participate has all been jeopardized by this late notice.
It's like calling an audible in the middle of a play. It happens so suddenly and quick.
Absolutely.
Right.
Right. I mean, we were going to ask at what point did everybody realize this was going to impact excess? And it sounds like the answer is at the very last minute.
Yeah, and I know we kind of thought maybe we're planning to discuss this later, but it's kind of right on point now, is that, well, what's the standard that the excess carrier has to deal with in terms of like it actually denying the claim, and why do they want to know, right? And the answers are, if you think about it this way, it's almost crazy, right? You can have a $1 or $2 million primary limit that is controlling the defense, and you have an excess carrier with $25 million of exposure above them, right? So you say, well, why do you want to know? Well, because I have a lot more at risk than you do, and I may want to associate in counsel. They may want to be more actively involved in the strategy and in understanding who's a good witness, who's a bad witness, right? So there that, and where that ties into the sort of legal standard is, have I been prejudiced because you waited so long to tell me, right? In certain types of coverage, you don't need to show prejudice, but with occurrence policies, which these usually are, you do. But insurance law is state law driven. And there's pretty much three splits in terms of how they analyze prejudice. In some states, if you gave late notice, you're out of luck, right? Um, there's other states where the carrier has to show that they were prejudiced. And that's what Cammie's talking about. It's like, look, if I was denied the opportunity to settle this earlier, cheaper, if I was denied the opportunity to, you know, to assess or impact or bring in better counsel, right? Or to move it to another state, all the things, right? That's prejudice. And then there are actually some states where there's a presumption of prejudice that's rebuttable. So, you're starting with I have to prove there wasn't prejudice, and then I can move forward on that denial. But that's the problem, right, with waiting on giving notice is if in fact the carrier has been prejudiced, you may end up in a situation where that coverage is impaired or gone.
Well, I know one thing we hear a lot is, well, the excess policy follows form, so, we're okay. Nothing's going to happen. Ari, why is that assumption becoming a little riskier these days?
Yeah, it seems to get riskier every day, to be perfectly honest. I mean, years ago, that was a safe assumption, right? Because follow form excess policies were 2 pages long and they had one sentence that said, we're going to do whatever those guys do. And you didn't have to worry about it. And over time, we still have that same sentence at the top. We're going to do whatever these guys do. But then they put another paragraph that says, except in all of these cases. And all of these cases takes up the next 10 pages of the policy. And it really is essentially a separate policy with separate terms and conditions.
Right.
And brokers and retail agents really cannot take for granted that follow form language anymore. I had a claim recently where, as part of the underwriting process and placing the policy, it was a complicated quota share with multiple carriers. And one of the biggest things they had to work out was sharing defense costs, right? If litigation happens, how are the defense costs going to be split among all these carriers? And they had this complex formula that the primary carrier agreed to and the excess carriers agreed to in theory, except when they issued the excess policy, it said, yeah, we follow form to all of this, except we're not going to agree to any of those defense cost things that the primary carrier said. And it was page 15 of the policy, and nobody realized that they hadn't actually agreed to everything, even though it was a follow form policy. And so the words follow form are still there, but the substance isn't what it used to be. So we really have to be careful, on the front end that we're getting what we think we're getting when it says follow form.
And what's crazy about that, right, is that you can have 10 carriers in a tower, right? And those 9 excess carriers each have their own independent terms and conditions in addition to following what's in the primary, except, as Ari points out, to the extent that it's not consistent with this other stuff we've now added, which a lot of times includes their notice provisions.
So it sounds like it kind of even goes beyond just reporting claims, but making sure that entire tower stays aligned.
Yeah, I think that's
right?
exactly right. Yeah, and especially when you're dealing with midterm changes. I mean, notice provisions are one of the ways in which you want to make sure the entire tower is aligned. But like we were just saying, right, there are any number of different conditions that excess carriers could add to their forms just past the sentence, we follow form to the primary, right? There's any number of things that could be down there. Sometimes they require separate endorsements for various things. I've seen a lot of different issues and requirements pop up in excess policies that were supposedly follow form. So as you're making those midterm changes or renewing policies, it's always worth double checking those excess forms to make sure you're getting what you think you're getting.
Well, you also have to consider whether this is an occurrence or a claims made policy, because we oftentimes see folks with excess claims made coverage and they don't want to put the excess on notice. However, that can jeopardize the notification portion of the policy, where you've got to report it within the policy period. But we've seen these guys want to report an excess when it develops into something, and then you're outside of their claims made policy period. That's an issue as well. Or certain types of exposures are only covered within the primary, and sometimes maybe the first layer, but anything above that does not cover that particular exposure. So that falls into the arena of making sure that your tower is aligned, as well as following the reporting guidelines.
So without naming names, when we think of those scenarios that all three of you have shared, I know they're probably burned on your brains, but when we think about what could make this claims process, this tower alignment smoother, it sounds like earlier communication involving specialists sooner, like Claims Advocacy team, and better documentation, right? Those three things, I guess they're kind of general, but communicate, document, tag, and help.
Your point about documenting is something you can't highlight enough, because there have been either when someone goes, well, it was a conversation, and or the person who was communicating on one end or the other is no longer at the company they were at when the conversation took place.
Right.
Right. So if you have a conversation about anything that's important, follow up and send an email just saying, hey, to confirm, right, the insured was comfortable with X, right?
No, that's perfect. All right, so let's just share a few quick practical tips for agents listening. Just quick, short answers, okay? When should agents notify excess carriers? As soon as the thought pops on your head, like Ari would say?
As soon as the thought's in your head, maybe even sooner.
Actually, in the perfect world, the excess is notified at the point the primary is notified, and then the primary adjuster information provided to the excess adjusters, so they have the opportunity to participate if they so choose.
Right.
Most of the time, those claims are going to be set up as record only and closed, and they're not going to monitor. But if that is the case, they have at their option, they can follow it, participate. Recently, well, actually this week, I had a scenario where we had placed all of the excess carriers on notice last year, and we received suit this week. So all we had to do was forward it to the adjusters who were previously assigned, note their claim number, suit has been filed.
Perfect.
That is the best case scenario. They're already on notice, and when something does develop, either litigation received or the primary has received a demand that is multiples of their limit, or in some cases they want full policy limits of anything that's available. We recently received one that was a $20 million demand. And in any of those cases where it escalates, they're already on notice.
Right.
So that's the best case scenario.
And in our world today, it feels like rule of thumb is it's going to escalate.
Right. When in doubt, notice, but also understand the terms in the policy, because some policies had, right, what they call the 7 deadly sins, right? If there's a head injury, a death, loss of a limb, that was a trigger for notice of an excess carrier. Some, if it's 50%, if you get through 50% of the policy, but understanding what those triggers are. And some say, basically, we want to know everything from day one, from which was less common, has become more common, where the excess carrier is basically saying, if it triggers the policy below me, I want to hear about it. So, understand the terms and conditions, and when in doubt, notice.
Right. Well, and something that we don't see as often is notice to the excess carriers, and we've got multiple layers of excess coverage. And then we've got a couple of large claims that suddenly erode the primary limit and possibly the first or even second excess layer. They're gone. So your third layer excess becomes your primary. And we had an incident of that recently where the primary first layer and the second layer were gone. And hello, third layer, you've got a mediation next week. So and because at that point they're primary. So that's an issue that we run into not nearly as often. We don't often see the complete erosion of excess layers, but it does happen.
Well, so it sounds like, if I'm a retail agent and I have a lot of insureds, a lot of clients, I should be talking with them like, hey, if you even think you've got a claim, please reach out to me, because there's no way one retail agent is going to automatically know all of that. So that sounds like a conversation that just needs to be had over and over and over again. Every renewal period, just reiterate the importance of that.
Absolutely. And I mean, the thing to remember is ignorance is not a defense, right? We get that a lot as well. This was an unsophisticated insurer. They didn't realize this was going to hit the layer. Doesn't matter. If the policy language requires notice after a certain set of circumstances are met, whether or not that insured realized it was going to hit the tower, doesn't really matter at the end of the day. So it really, that communication, those conversations, you're exactly right. Those are huge.
There are no certainties, so we don't have a crystal ball,
Right.
to know.
Right.
If we did, let's be clear, if any of us had a crystal ball, we would not be working here right now.
Right.
Right. Right.
Cammie coming through at the end with the thing to put on the T-shirt. There are no certainties. We don't
That's
have
right.
a crystal
There
ball.
are no certainties.
I love
There it
that
is.
when we talk, because my favorite part about the podcast when we talk to people are the real world examples. And when we talk to claims folks, that's all y'all have. So I love hearing about the actual things that
we don't
actually
have
happen on the ground.
hypotheticals.
Right. Exactly. Does anyone have any closing remarks they want to add before we get to the fun stuff? I think we've covered a lot of ground.
You guys have done a great job.
Well, we'd like to do something at the end of the podcast called Rapid Fire, where we just ask you questions and you answer off the top of your head. There are no wrong or right answers unless you make them right or wrong. So here's our first question for you guys. We'll start with David on this one. You can master one skill in a day. What is it? It does not have to be work or insurance related, and it's more fun if it isn't.
I'd like to learn to fly, right?
Right, like Superman stuff.
And I don't mean a plane.
Like a superhero.
If I could pick a skill, that would be my first one.
Dave went much more high level than I was thinking. That's a really good one. I was just thinking I've always wanted to learn to play piano, and I've never been able to do it. But now I'm kind of rethinking it after that flying one. That sounds a lot better, to be honest.
Oh, mine would be anything construction related. I'm a huge DIY show fan, so give me a tool belt and a power tool, and I'd love to learn carpentry as an example. So.
Wow. I had a friend who learned it later, well, not later in life. He's not that old, but he took it up and now he's doing like master level stuff. So yeah, it's something you can pick up.
Cool.
Okay. Next question. What weird thing, let's start with David on this one. What weird thing did you collect as a child?
Yeah. The answer
We know you've
would
got
be-
collections, David.
Right. I was going to say
Yeah.
it's the same stuff I still collect or have. I mean, I collected comic books from when I was 5 years old.
Never stop.
And I
Nice.
still collect them and have an enormous comic book collection. I have a meteor, right? I mean, I collect. So yeah, those would be my two big ones.
That's always a hard act to follow. But I guess if it's strictly as a child, and I'll tell my age here, it would have been Tiger Beat posters.
Oh, wow.
Yes.
All right.
Yes, I remember
There you
those.
go.
David Partridge, or was it?
Oh, David Cassidy, of course.
Yeah.
David Cassidy.
Yeah.
Yeah.
Had the T-shirt.
That's funny. I
Ari,
collected
what about
baseball
you?
Cards. Yeah, I collected baseball cards as a kid, which wasn't particularly weird. Most of my friends did, but I had this weird obsession with Hard Rock cafes when I was a kid. So like anywhere we went, I would go get like a t-shirt or a shot glass or something. It got to the point where when I was in college, we went, we did like the backpacking through Europe for a couple weeks, and all my friends, like I insisted on going to a Hard Rock cafe in every city we were in so I could get like a shot glass. It was insane. I mean, it's really embarrassing.
Where are they now?
No.
I don't know the answer to that. I don't know where they are now. They might be in storage. I might have thrown them away. I no longer collect Hard Rock Cafe items. I'm really happy to admit that I'm now in recovery and it's not a thing for me anymore.
I'm glad you clarified that, because I'm thinking, were you 5 when you were collecting shot glasses, or?
I didn't know what they were, right? But
they were just
Tiny
small
juice
and cute.
glasses, yeah.
They were cute.
Yeah.
I want to know, Amanda, your collections as a child. What was yours?
I grew up on a farm, so we were constantly outside. We collected, I don't think it's weird, but we used to collect, there was gravel everywhere and the fields were constantly plowed. So the little tiny stone beads and the arrowheads that you'd find digging, we had boxes. And I don't have them anymore, but now my kids, gem mining, right? Every time you go somewhere and there's that touristy gem mining.
Yep.
Right.
I think they'd still do it to this day. I have boxes of random rocks all over the house.
Oh, yeah.
I'm going to make them take them when they move out.
I was a Star Wars boy, so I had those and the comic books and the baseball cards, which I
There you
still
go.
have.
Did them all.
All right,
Yeah.
moving right along.
Last
so
question.
our third and final question. What is the most interesting thing in your fridge or freezer right now?
Let's not turn this into a true crime podcast. Let's go with
Yeah, no, I don't.
No bodies.
I don't need to know about hands.
And
Yeah, no
bodies.
hands.
I have these molds that I use. I really like, if you go to a bar and you get like a clear cube of ice, that
Yeah.
you can
Right.
really see through the bottom. So I bought this like contraption where you can make these clear ice cubes at home. It's not that interesting, but that's probably the most interesting thing
That's
in
pretty
my
cool.
freezer at the moment.
That's pretty cool.
Better than just pizza, right?
Right.
Yeah.
I wish there was pizza in my fridge right now.
It's harder than you think, guys. Don't you have to put the halves together at some point, Ari?
Oh yeah, it's a whole
Yeah.
thing, and it's like hot water, and there's got to be enough space between the mold and the bottom of the contraption so the air can do something. It's all science, apparently.
Science/magic.
Right. /magic.
Yeah.
Anyone else?
All right. Anybody else? Dave, there's got to be something weird in your fridge right now.
Well, we have, like, honestly, we have, let's see, 1, 2, 3 refrigerators that each have a freezer and then have a big, like, freezer. And I don't know if it's still there, but my oldest son, both boys like to cook, but he made something with like bear meat and it was kept in a thing in a bag somewhere. And so I don't know, but I'm not great at doing that, but you really do need to go through your refrigerator and freezer and find all the crap in the back and throw it out. And I mean, I do
Yep.
get made fun of in my house for like, somebody will look and go, this expired. Like, you say, oh, I need aspirin or something, probably a little, an antibiotic. And they look and they go, this is like expired in 2017, and I'm like,
Right.
yeah, I know it looks fresh. So no.
It was in the freezer. It's fine.
Right.
Doesn't smell bad.
Okay.
Well, I would say that my most unusual item in the refrigerator would be my husband's homemade moonshine.
All right.
Mm.
Ah,
There you go.
wow. Does he make it in the bathtub?
No, he has
Oh,
a
that's
still.
gin. Sorry, that's bathtub gin.
There
He
you
has a
go.
still.
Wow,
Nice.
nice.
I
Pretty
think
cool.
Cammie wins that round.
Yeah.
Is it,
100%.
does he flavor it or is it just like pure?
Yes, some of it,
Like-
yes.
Cool.
Yeah.
Oh,
it's a
yeah,
thing.
we've got some flavored as well as straight up.
Very
Well,
cool.
I think we learned a lot about each other, more than was necessary.
That's right.
Well, I think we had a good one, David.
We
All right,
did.
Cammie, thank you for joining us and, for
Sure.
helping us break down a topic that a lot of people find intimidating, but it's very important. So thanks for being here.
Yeah, no, we appreciate you
Sure,
guys,
Thank
picking this and guiding us through, right?
Of course. And to all of our listeners, the big takeaway today is actually very simple. Don't wait. Early communication, understanding policy, language, terms, and conditions, and involving the right partners early can make all the difference when a claim starts moving toward the excess layers. When in doubt, reach out to your CRC specialty contact for assistance. Thanks for listening to Placing You First. We'll see you next time.
Are you ready to move faster and go further? Take your career to the next level. Join Team CRC to gain access to best-in-class tools, data, exclusive programs, and more. Send your resume to resumes@crcgroup.com and read testimonials from recent hires on LinkedIn.
Search for CRC Group.